Welcome viewers. When the law changes character, offence today, silence tomorrow. When the same law seems to mean different things in the same court in Australia. Pauline Hanson versus Faruqi. When the same law seems to mean different things in the same court. Viewers, imagine you're Pauline Hanson. You've made a harsh and offensive political comment. Many people dislike what you said. Many like what you said. Some may dislike you before the case even begins. But the court's not supposed to decide whether you are popular, polite, or likeable. The court must answer a more important question. Did the Australian Parliament have the constitutional power to make this kind of speech lawful? And that's the real issue. Section 18C of the Racial Discrimination Act makes it unlawful to publicly offend, insult, humiliate or intimidate someone because of their race, colour or national or ethnic background. And it is a civil law, not a criminal law. Pauline Hanson's argument's not simply that she should be allowed to say anything she likes. Her argument is that the Commonwealth government must prove it had constitutional power to create this law. The Commonwealth says that power comes from an international racial discrimination treaty Australia signed. But this creates the first problem. The treaty mainly deals with very serious conduct, including racial hatred, racial superiority, encouraging discrimination, encouraging violence, and actual violence. It also says freedom of speech must be considered. Section 18C goes further. It can apply to speech that causes serious offence or insult, even when there is no violence, no call for violence, and no attempt to create racial hatred. So the simple question is, how can a treaty aim mainly at racial hatred, discrimination and violence be used to support a law that also punishes offence and insult? The court answered that Parliament does not have to copy the treaty exactly. It said Parliament may create broader laws if those laws are reasonably connected to the treaty's purpose. That explanation allowed the court to say Section 18C was constitutionally supported. But then the argument changed. When the court considered whether Section 18C unfairly restricted political communication, it described the law differently. Now, the law was said to be about protecting people from serious racial harm, encouraging civility and supporting social cohesion. And this is where an ordinary person may reasonably become confused. When the court needed to prove that the Commonwealth had power, the law was connected to an international treaty about racial discrimination. And when the court needed to defend the law against freedom of political communication, the law became a protective law about offence, dignity, civility and social harmony. The same law appeared to take on different purpose depending on which legal challenge it was facing. It morphed. And that's the central problem. The concern's not simply that Pauline Hanson lost. The concern is that the legal explanation appears to move, drift, morph. And if the meaning and purpose of a law can change during different parts of the same case, how can an ordinary Australian know where the legal boundary really stands? A citizen may ask, is strong political speech unlawful because it is offensive? Does it need to cause serious harm? Does it need to encourage hatred? Does it need to threaten social cohesion? Does it depend on who said it? Does it depend on who heard it? Does it depend on how a particular judge understands the harm? And these questions, viewers, matter because Section 18C uses words such as offend and insult. Those words depend heavily on judgment. Different people may understand them differently. Different judges may also place different weight on free speech, racial harm, and public order and social unity. One group of judges may believe offence speech must be restricted before it becomes something worse. Another group may believe democracy must allow harsh, upsetting, and divisive political arguments unless they create real and serious harm. And this is what is meant by different bench approaches. It does not automatically mean that judges are corrupt. It does not prove that they are secretly helping one political side. The danger is more complicated. Judges bring different legal beliefs, priorities and views about society into difficult constitutional cases. One judge may place greater importance on protecting people from racial harm. Another may place greater importance on protecting political speech. Both may believe they are correctly applying the law. But they may reach different outcomes. That makes the law harder for ordinary people to predict, because the court itself accepted that Section 18C covers a wide area. It accepted that the words offend and insult create a relatively low entry point. It accepted that the law places a significant burden on political communication. It also accepted that people may silence themselves because they fear legal action. But despite this, the court still decided that the law was properly balanced. That creates a serious practical consequence. A politician, journalist, religious speaker, activist, or ordinary citizen may not know in advance whether strong political speech will be protected or punished. And the answer may depend on how a future court describes the purpose of the law, the seriousness of the offence, the meaning of harm, the importance of social cohesion, and the value of the political communication. And this uncertainty can change public behaviour because people may stop discussing difficult subjects. They may avoid immigration, religion, race, culture, and national identity. They may remain silent not because their speech is clearly unlawful, but because they cannot confidently predict how a court may later judge it. And that's the deeper danger. A free society does not only lose speech when a person is punished, it can also lose speech when people become too frightened to speak. And there's another important concern, isn't it? The attachment argues that the full federal court did not properly address recent High Court decisions dealing with political communication, disagreement, and actual public harm. That does not automatically make the judgment invalid, but it raises a fair question, and that question is, were all the most important constitutional principles properly considered before the court restricted political speech? And from Pauline Hanson's position, viewers, the case is therefore about much more than one offensive tweet. It's about whether constitutional rules remain stable when the speaker is unpopular. You see, it's easy to defend freedom of speech when the speaker is respectful and widely supported. The true contest comes when the speaker is disliked and the words are offensive. So the final issue was simple. The court had every right to condemn the nature of the comment. But constitutional law must do more than express disapproval. It must clearly explain where the Commonwealth obtained its power, what the law actually is designed to prevent, why political speech may be restricted, and where the legal boundary now stands. And if those answers change depending on which part of the case is being discussed, ordinary Australians are left with uncertainty. The real warning is therefore not that every judge is biased. The warning is that a broad law, unclear boundaries and flexible legal tests can produce different results before different judges. I want to read that again. The warning is that a broad law, unclear boundaries and flexible legal tests can produce different results before different judges. And when people cannot clearly understand what the law permits, they begin censoring themselves. And when ordinary Australians are afraid to enter political debate, the damage reaches far beyond Pauline Hanson. It reaches democracy itself.